this joint managing conservatorship or joint decision making is the default now. Historically, in the 80s, it was not available in Texas. And then it became available. It came from California. It became available only if the parents agreed, with the assumption, and I think a pretty strong case could be made, that if the parents don't get along well enough to stay married, why would they get along well enough to raise children together after that? Well, what we found is a lot of parents don't disagree about children. They're arguing about money. They have their own issues that life was supposed to be better than this. They have developed other interests. They have grown apart, but that does not mean they disagree on their children. So it has now become the default. So in terms of your ability for creative solutions here, in my experience, there's 3 key areas that you should focus on. The first one is education. The second one is psychological and psychiatric. And the third one is elective, invasive medical treatment. There's some other, I would call them insignificant, like whether or not a child needs to hire a lawyer in the event that he or she has a lawsuit, or whether the child gets to join the Army or get married before they're 18. Those don't come up very often. But those 3 do. And I've had lawsuits over whether or not children can be homeschooled or not. Okay? I've had lawsuits over invasive medical treatment because one of the parents was a Jehovah's Witness and didn't believe in blood transfusions, and the kid liked to ride bulls. Okay? So, what you can do in mediation or in settlement is you can develop creative sharing of those rights. It's not uncommon to let one parent make educational decisions and the other parent to make psychological and medical decisions. It's not uncommon if someone is medically trained to get to make the medical and then share the other 2. We do a lot of, if you're unable to agree, you will take it to a parenting coordinator or to a parenting facilitator. Sometimes we appoint a tiebreaker. Because in my experience, if you're representing the mom and you've got what apparently is a deadbeat dad, okay, not spent a lot of time with the children and not been very involved with them, it's a disservice to the children to let mom be sole managing conservator. Dad needs to be able to tell his friends he has joint managing conservatorship. It is important for him. It will encourage him to be involved in ways I think that would surprise you. The other thing that would surprise you is that a lot of times the reason fathers are not very involved with their children when they're married is because they don't want to go home. It's not much fun there. And what they will tell you is, my God, now that I'm separating, I'm seeing my children more and I love it. So that's part of the challenge you've got when you're representing a mom, is to make sure she doesn't over-litigate it and overplay her hand because she has a better case in court at that moment. It's just one of the things I think you can do to help those children.